Thank you very much for joining us for what I hope will be a very useful webinar discussion about a topic that is tough to define and tough to address, and that is data governance overall as a concept. My name's Peter Stockburger. I'm the managing partner for the San Diego office of Dentons. For those not familiar, Dentons is a global law firm. In fact, we're the largest law firm in the world with offices all over the world, including throughout the United States. And my practice focuses on all things data, data privacy, data security, AI, and really all of those fall under the umbrella of data governance. Today, what I wanted to focus on in the discussion was looking at this concept of data governance and how it can be used both to drive compliance, but also drive business functionality. And I'm going to break up the discussion into three parts. Throughout the discussion, if you have any questions, please pop them into the chat function, and I'll be happy to address them as we go through the discussion. And we'll have some Q&A time at the end. But the three components I want to focus on is, what is data governance as a concept, and why is it important in today's business environment? Second, what are the legal trends, both globally and here in California and throughout the United States, that are driving the need to address data governance as an overall concept? And then ultimately, what actionable insights are there that you can take in your organization to ultimately raise your data governance game and increase your control over this issue? And so whenever I'm talking about data governance with lawyers, one of the first issues that comes to mind is, oh, well, it's a data privacy compliance issue, or it's a data security issue, or it's an IP issue. And really, data governance is a much broader concept than just one singular area of law. When I think about data governance, I think of it as a principled approach to managing enterprise data across the data lifecycle. So this is a principles-based approach that drives how you collect, classify, use, and dispose of data. Not just personal information in the privacy space, but also your trade secrets, business confidential data, any data that your business is sort of acquiring or developing. Data governance is an overall structure around that data. And one of the material term here is a principle-based approach. I would say the biggest hurdle to driving data governance as a cultural issue within enterprises is the concept of, well, there's just going to be more policies, more retention policies that no one's going to follow, and it's going to get lost in the mix. A principled approach instead talks about things like notice and consent, transparency, data minimization. These are principles that drive decisions around data that aren't necessarily tied to a particular policy or legal framework, but are principles that everyone has in mind. When we're collecting and using data, are we thinking about transparency? Are we thinking about data minimization? And data governance as a concept can take the form, can be actually fleshed out in policies and procedures and training and cultural practices, but it's an approach to data versus here's our single data governance policy. And the reason why data governance is so important in today's business environment, in my judgment, is because it allows the business to harness the benefit of data while mitigating the risk associated with data. And when I talk about promise and peril, this is promise of leveraging your confidential data, your insights, your analytics, your customer data. It's also managing risks around that: litigation risk, regulatory risk, financial risk, reputational risk. And so good data governance, a robust data governance program, can maximize the value of your data while satisfying your compliance, your legal, your financial, and your reputational risk needs. And that's the sweet spot, is getting that balance right. It's not being overly compliant or overly restrictive, and it's also not being overly permissive with your data. It's finding the right measurement. And that's the what and the why as to why data governance is becoming such an important concept. What are those promises? What are those benefits of getting data governance right? Well, you've got better data quality, because as you go through this exercise of data governance, you're going to have better visibility into the types and scope of data that your organization has. You're going to be able to enhance your security around highly sensitive data, enhance your ability to comply with the ever-shifting regulatory and legal landscape. You're going to be able to make better decisions about how to use data, how to leverage data, and what your future use cases are going to be. Increase efficiency, increase your risk management, save money, enhance trust. All benefits that come with good data governance. But obviously, it's not a rosy picture all the time, and there are real operational challenges to implementing a data governance program. One of the biggest challenges that any enterprise has in putting together robust data governance is organizational culture, resistance to change. People are used to doing things the way they do them. Convincing folks to change the way they store data, classify data, organize their email inbox is not an easy road. And this is where this concept of policy versus principle really comes into play, because I truly believe, based on my experience working with organizations from startups all the way to very successful organizations, when data governance is being pushed down as a matter of policy to employees and those frontline stakeholders that are in control of the data, there's resistance. But when it's premised on a sense of we've got a set of principles that we adhere to, we adhere to principles of transparency and minimization, it gives folks flexibility to figure out what works best for their particular department. But organizational culture can certainly be a hurdle in driving forward one of these programs. Data silos is also a significant challenge for most organizations. For many, I would say, data is siloed between business units, not communicating with each other. There's also a lot of unstructured data that folks don't have their arms around. So fragmented data and fragmented departments can often make it difficult to establish robust data governance. But it's a problem that can be overcome, but it's a problem that has to be named and challenged. Resource constraints are also a significant challenge in today's economic environment. Limited budgets, limited staff can significantly impede the development. And data governance can be complex. It's not a simple set it and forget it type of compliance program. It's a cultural shift. It's a mindset, and it's cross-functional. HR, business, marketing, legal, privacy, security are all involved in robust data governance. And so scope and complexity can be a challenge to implementation. Ultimately, I also think rapid technological changes are becoming a challenge for data governance. A lot of clients I work with that have data governance boards or data governance committees are struggling to keep up with AI, for example, and how data is being used and transmitted through those tools. So these are all challenges that we know exist. They're all, I would say, conquerable, but it's important to flag them as you engage in sort of a data governance journey. Data governance as a concept isn't often used as a phrase. You sometimes see it used, but it really manifests itself in a number of areas. This is a snapshot of the key findings from the ACC's 2024 survey of chief legal officers, and you can see data governance sewn throughout these top concerns. Number 3, data breaches are still the biggest data-related threat that CLOs want to mitigate in 2024. Figuring out how to prevent a data breach, that is, what security controls do we need to put around and what data needs to be secured, is a data governance challenge. You need to know what data you have and why it's sensitive and how it's being protected in order to proactively prevent the data breach from occurring. And when the data breach does occur, if you don't have good data governance in place, you're going to be spinning your wheels and trying to figure out what happened and the potential exposure. Number 2, regulations and enforcement keep CLOs up at night. Privacy and data security regulations and cybersecurity threats, 41% and 37% respectively, demonstrating that there's concern keeping CLOs up at night because there's not confidence in how data is being governed at the business level. Another reason why data governance, I think, is becoming a business imperative. And number 7, most CLOs believe that AI is going to have an impact on the profession of law, and that certainly is an opinion out there. There's others that feel that AI is being overhyped. No matter what your position is on the AI hype cycle, data is a core component of using AI. So I wanted to provide you this snapshot to show that practically at the business level and at the legal level, data governance is really permeating throughout as a theme. I also wanted to give you an example of where this challenge comes up. And one of which is deploying AI tools within your organization. So right now we have a plethora of AI tools that are on the marketplace, and the enterprise tools in particular are attractive. And Microsoft Copilot is a program that many organizations are starting to consider or are examining at the moment. And Copilot is not a magic tool that solves all your problems as an organization. It instead performs tasks within the Microsoft 365 app environment based on the data that you provide it. So this is a chart that Microsoft put out on one of its blog posts showing how the sausage is made in Microsoft Copilot. And so on the top left-hand corner, you can see the Microsoft 360 apps that you all engage with, Word, PowerPoint, Excel. And the user of those tools, when Copilot is engaged, can type in a prompt, generate me a slide deck showing the company's financial performance through Q3. That prompt then goes through Microsoft Graph, which is the back end where you have permissioned data to be used for Microsoft Copilot. This is the data governance challenge. So this is the bottom left-hand corner. In order for Peter, let's say in the legal department, to run a PowerPoint slide deck on financial performance for the first 3 quarters, Microsoft needs to know that Peter has permission as a user to access all of the data, files, emails, chats that relate to financial performance. So you have to have actually data governance and classification to those data files in order to give permissions for Microsoft Copilot to work its magic and come back with a generated slide deck. That requires an extraordinary amount of fidelity to your data and to users. And this is just a real practical example about lack of good data governance can result in the inability to truly use an AI tool to its fullest extent. I have a lot of clients that are using Copilot or piloting Copilot, no pun intended, to perform certain tasks, but they can't quite leverage it to the extent they want to because they don't have good data governance in place. I just wanted to provide you this as a practical example of a business challenge and an opportunity lost to the extent data governance is not thought about at the outset. So before I give you an overview of where the law sits on data governance and why it's presenting a particular legal risk, I did want to spend some time to give you what I think are the 4 pillars of a data governance program. And I say here on top, it's an all hands on deck approach. And that's because each one of these 4 pillars is not something that legal controls solely or security controls. It's got to be cross-functional within the organization. Legal, HR, privacy, security, all participating, all rowing in the right direction with a principle-based approach to governing data and protecting data. Step number 1, no matter where you are in this data governance trajectory, is mapping your data. What data do we have? Where is it stored? How is it being used? And these are critical questions that must be answered first before anything else can happen around data. The challenge here is how do you get that information? And that's where most organizations run into a roadblock because this information is not kept in a central source. And so you've got to go to the business units, the individuals engaging with data, collecting data, using applications to find out how they're using it. Now, data mapping is an exercise that can be done through third-party vendor sources. Companies like OneTrust and Xtero offer services where you can push out questionnaires and collect information that way. Other organizations do this more manually, where they're having direct conversations with the leads of different business units to find out how is data being used, where is it being stored. Ultimately, there's a gathering process, a hunting and gathering of the facts. And then there's a process of how do you keep that list updated? Do you send out quarterly questionnaires? Do you have meetings once a month or send out emails saying, has anything been updated? But this mapping exercise is really important. I think there are a couple of advantages to doing the mapping where you have direct conversations. You can oftentimes get more buy-in and find out the hidden rocks that you wouldn't necessarily find in a survey to figure out how folks are using applications and data. So that mapping exercise is critically important, a very important pillar, no matter what type of data your organization deals with, to figuring out your governance approach. The second pillar is once you have that factual information, is you have to figure out how to classify that data. What is going to be considered business confidential? What is going to be considered personal, sensitive personal data? Do we have security controls or use limitations that need to be placed around certain categories of data? And how do we address unstructured data that we don't quite have our arms around? And there's really no simple answer to this approach. Every organization does data classification a bit differently. I would say some of the pain points in the classification process, which is not an easy lift, are can you automate classification and controls, or is it going to be manual? The third pillar in a data governance program is actually executing on the classification scheme. Do you have a policy in place to talk about what controls you put around certain classifications of data? Do you have a data minimization policy in place, depending on the jurisdiction you're operating in, to say, we will only use data so much as reasonably necessary to achieve X purpose? And then ultimately, what are the data value propositions that you haven't yet considered? For example, are you in an industry where today you may not have a lot of value locked up in your data, but in 5 years from now, could you be in a position to be licensing data to some of the larger AI companies? For example, we just saw Reddit sign a $60 million license deal for all of their user comments to Google. So there are value propositions in data that get unlocked in this governance policy because you're able to protect the data as trade secret or confidential. And then finally, how are you retaining data? Do you have a schedule governing how business records are to be kept? Are you understanding the full length, the full breadth of your legal obligations around retention? And how do you get participation in retention? And one of the biggest challenges in data governance is convincing people to delete stuff. People use their emails as data archives. Folks have stuff on shared drives, on local drives. And how do you get buy-in from the organization? And at the end of this discussion on my key takeaways, I've got some experience and tips on how to motivate the workforce on retention. But in my view, these are the 4 critical pillars on data governance. Without them, you can't really have robust data governance, no matter you're talking about privacy, security, IP protection. These are the 4 horsemen governing that program. So with that table setting of what is data compliance, why is data compliance or data governance important, and what are the pillars, I want to spend some time looking at what's the legal challenge around data governance. Where is the data governance conversation moving? And I would say historically, data governance as a concept was largely seen as either a business need, you need to protect your IP, you need to protect your trade secrets, or a security need. Well, we need to know what cybersecurity controls we need to have in place. Increasingly, however, we have new and emerging data privacy laws, regulatory positions being taken at the federal and state level, litigation trends, especially here in California, and shifting rules around AI that are now introducing new concepts that are putting data governance as a concept into the law. And that, if you're looking for what's the reason we need to jumpstart our approach to data governance, this is one area that is driving that need. From a global standpoint, well, I wanted to highlight this is not just a US issue. There are global trends at work around data governance in North America, Europe, Asia, Latin America, and India. And North America, we see the US legal markets as well as Canada shifting in their approach to data collection and use. This is largely with regard to personal information. There are trade secret laws that are also complex. Obviously, in the US, we have almost 50 different state trade secret laws. We have a federal trade secret law, and the IP protections are robust. But it's fast moving in the US and in the legal markets. In Europe, we also have data privacy laws, the GDPR and others that focus on having a legitimate basis for collecting and using data. So you really have to have your arms around the data from a governance perspective in order to meet the data minimization standards there and also satisfy the strict data transfer requirements. Asia and Latin America are also fast moving in this space, adopting robust data minimization principles and data transfer protocols. And India really is a jurisdiction that I'm keeping an eye on, and it's becoming a real hotbed for data regulation. There's a new data privacy law in India that was passed last year. We're still waiting on new data privacy regulations to be implemented there after the election. And there are AI laws and other data minimization laws being considered at the federal level in India. Dentons is actually the first law firm to open an office, a global law firm in India. So we've got our ears on the ground there. But globally, we're moving toward a global regime, where the laws governing personal information, also governing trade secrets and IP protections, are putting in place data governance requirements that are now justifying putting in place data governance programs within organizations. I would say at the US level, the biggest challenge around data governance right now is privacy and security. And the US landscape around data privacy, highly balkanized. We do not have a federal data privacy law that governs all 50 states. Instead, at the federal level, we have pockets of data privacy and security requirements, children's law under COPPA, unfair business practice protections under the FTC. We have federal financial privacy laws, healthcare privacy laws. And at the state level, it's even more complicated. We have 50 data breach and security laws, 20 states now that have omnibus consumer data privacy laws. There's health information, cybersecurity, surveillance rules, biometric rules, insurance rules. So really, no matter what the industry and sector you're in, data privacy laws are tightening the screws around this concept of data governance. And at the federal level, some interesting trends we're seeing are that the FTC and other regulators are highly, highly focused on this issue of obtaining notice and consent from consumers when collecting their data. The FTC is particularly concerned about the use of tracking pixels on websites and consumers not truly understanding the full scope of information that's being collected about them. And so this is where data governance comes into place, because understanding the types of tools you're deploying on your mobile applications, on your websites, will give you the insights you need to understand whether a notice regime or a consent regime or really just an opt-out regime is appropriate for your organization to align with the FTC's expectations. Now, of course, we're in an election year, and if the party in power changes next year, we could see a completely different approach from the FTC. But for now, they're highly focused on this issue of notice and consent. We also see a federal trend around fidelity to data in deployment of AI. The FTC is very clear that you should not be using AI in a way that results in unfair business practices. The EEOC has robust guidance around deploying AI in the employment context. And the Department of Justice and others have said, we're going to enforce our current laws in the deployment of AI. And how you actually deploy AI, what you tell people, and the fidelity to the data is becoming a point of contention at the federal level. Finally, the concept of data minimization, this principle, getting back to the principled approach of saying you're not going to collect, use, store, or share data beyond what is reasonably necessary, is not a concept that is applicable across all 50 states. This is more a legal concept that comes from Europe that views data privacy as a human right under the European Convention on Human Rights. But we're starting to see it percolate more in federal bills and federal proposals around data privacy. There's a federal data privacy law, for example, that's been proposed, the American Privacy Rights Act, that has built into it a data minimization principle that would apply to all 50 states and to which there would be attached a private right of action. You could get sued for over retaining or over collecting data. Now, that bill is still in draft format. There have been several hearings on it. Observers are highly skeptical that it's going to get much traction in a presidential year. But there is focus on this issue at the federal level. I think we're seeing even more focus on data governance at the state level. I mentioned earlier, we now have 20 states that have omnibus data privacy laws that are European-like. Here in California, as many of you all know, we have the California Consumer Privacy Act, the CCPA, that's been in effect since 2020, and an amended version has been in effect since January 1 of 2023. But laws in Colorado, Virginia, Utah, Connecticut, Texas, and Oregon are all in place today that impose data minimization principles as a matter of law if you are collecting, using, storing, sharing the personal data of a resident of those states. And what those, I'll give you an example of California's data minimization principle. In California, the law says if you're subject to the CCPA and you're collecting a California resident's personal information, you can only do so to the extent it's reasonably necessary and aligned with the reasonable expectations of the consumer. The CCPA regulations, which took effect to all covered businesses under the CCPA, put guardrails around what that analysis looks like. And you have to weigh multiple factors in determining whether it's reasonably necessary to use the data or collect the data. If you don't satisfy that test, you need to get opt-in consent from the individual before using their data. So notice and consent is now creeping into the US state legal market. By way of another example, the Washington My Health, My Data Act, which took effect this year and has a private right of action attached to it, says if you are collecting the information about the physical or mental health condition of a Washington resident, you must obtain consent and provide very express and specific notice about that use case. That's not HIPAA data. That's data like saying, do you have acne? We would like to sell you an acne product. That's information about a physical health condition. So notice and consent is rapidly expanding in these state data privacy laws. Data security is also an area at the state level where we're seeing data governance become an issue. Historically, from a cybersecurity standpoint, most states simply say, if you are collecting the personal identifying information of a resident of our state, then you need to maintain reasonable security around that data. Now, historically, personal identifying information, so PII, was defined as name plus something highly sensitive, like social security number or driver's license number, a piece of data that you could steal someone's identity with. That's what, for example, the California Records Act says you need to maintain reasonable security around that specific type of data. And if you have a data breach, it's that specific type of data that triggers your notice obligations. What's happening, though, is in states like Colorado, Virginia, Connecticut, and Utah, not California, interestingly, but in the other states that have omnibus data privacy laws, they are building into those laws a provision that says you must maintain reasonable security around personal data, which is a much broader set of data than just that PII narrow set. So name and email address, you need to maintain reasonable security around that. The reason why that's important for data governance is because most organizations are not putting robust security controls around databases that just have somebody's name or somebody's email, because that's not being classified as sensitive data for the purposes of security controls, getting back to that mapping and classifying exercise. So this gives you an example of where if you don't map and classify carefully, you could be running afoul of a US state privacy law, even though it's purely a question of security controls. Finally, trade secret protections. This part is particularly complex when we talk about AI, because each of the 50 states has a different or similar, but sometimes different tests for what constitutes a trade secret. In California, for example, you need to have some sort of unique compilation of data or process that you derive economic value from, and that making public you would lose value if you made it public. And do you have controls around keeping it secret? Well, if you are introducing AI and data is flowing to an AI tool, have you lost your trade secret protection? Is there data security obligations that get brought in, or data privacy? So you can see where the mapping and classifying becomes critically important from a state compliance standpoint. And I did just want to put a bit of a finer point on this state compliance issue. This is an example. This is an enforcement advisory that the California Privacy Protection Agency, which is the enforcement arm under the CCPA here in California, they issued their first ever enforcement advisory this year, and it was specifically around the principle of data minimization. And you can see right here in the first line of their enforcement advisory, data minimization is a foundational principle in the CCPA, getting back to our principles language. And what this principle says is that you shouldn't be collecting, using, retaining, or sharing personal information of a California resident beyond what is reasonably necessary, or you're going to need to get consent. This particular advisory was about asking consumers to verify their identity as part of data subject requests. So what the CPPA said is, hey, when you're asking people to verify their identity, when they're submitting a request to access their data, delete their data, opt out of the sale of data, you need to be very circumspect in what you're asking for. And don't over request data and don't over retain data. So I think that the key takeaway here is data minimization requires very careful oversight on the collection, classification, and retention prongs of a data governance program. Another example is an enforcement case, and I'll give you 3 of the enforcement cases that we have now from the California Attorney General's office under the CCPA that really bring home the business impact of not getting data governance right. In August of 2022, the California Attorney General's office, in a first of its kind, announced a settlement with Sephora under the CCPA. And what the Attorney General alleged, and I want to emphasize that this wasn't proven, this was alleged, and then there was a settlement. But the AG alleged that Sephora was not disclosing to consumers that it was selling personal information through the use of third-party tracking technologies like analytics companies. And so this gets to a data governance question: is, do you know all of the third-party analytics companies and providers that are operating on your website? And if so, have you mapped whether or not it's a sale of data or not? This becomes particularly tricky when you talk about mobile applications and software development kits, which I'll speak about in a moment. But I think the key takeaway here with Sephora is mapping the sale of data through the use of cookies. This was a significant one because Sephora agreed to pay $1.2 million in penalties, and there were some pretty restrictive injunctive terms. So this is one example of where this concept of data governance is coming into play from a regular standpoint. Another example is the second enforcement action announced by the California Attorney General's office under the CCPA against DoorDash. And interestingly, the claim here was brought against DoorDash both under the CCPA as well as the California Online Privacy Protection Act, which is an old law that's decades old that relates to posting a privacy policy that at the very minimum describes the categories of data being used and collected and shared. And the allegation, again, allegation because it was settled, was that DoorDash was selling customer personal information without notice, without the opportunity to opt out, to a marketing collective that was collecting information from multiple companies and then allowing those participants to market to those individual consumers. Again, this gets to a data mapping and governance exercise because from a robust data governance perspective, you would want to map where data is being shared with a marketing collective and what type of notice is required out of that. This one resulted in a $375,000 penalty. There was injunctive relief tied to this enforcement action and a duty to provide annual reports to the AG on ongoing sale or sharing of information. So another example of where data governance is coming in with some teeth behind it. The third example actually was just recently. The California Attorney General's Office and the Los Angeles City Attorney brought a claim against Tilting Point Media. They make the SpongeBob SquarePants mobile app game, amongst others. And the allegation here was that Tilting Point Media violated both the CCPA as well as the Children's Online Privacy Protection Act because they were not giving appropriate notice or obtaining consent of children's data who were downloading and using the app. A few interesting things about this case around data governance that I think is a key takeaway for everyone on this webinar. One is the fact that it was brought by both the Attorney General's office and the LA City Attorney raised some eyebrows. So a lot of folks thought, well, how can the CCPA be enforced by the LA City Attorney's office? That's because the CCPA has a particular provision that says an unfair business practice claim or tag-along claim can be brought by a regulatory agency or a city attorney or district attorney's office. So they are permitted to team up with the AG, and they did so in this case. The specific allegation in this case that I think touches on data governance is around the use of software development kits in the mobile application. And this is a very important, I think, material point. If you walk away with anything from this webinar, walk away with the lessons learned around SDKs. Software development kits are basically libraries of programming that application developers can use as a building block to build a mobile application. So you don't have to code everything from scratch. And these software development kits oftentimes include in them third-party analytics software. And so when you are developing and building your mobile application and users are using the mobile application, data about the user of the mobile app is going to these third parties to provide you back with analytics about how the app is being used, how it's being downloaded, for bug reporting. And the allegation in this complaint was that Tilting Point Media misconfigured the SDK, and it allowed children's data, especially children under the age of 13, but also children between 13 and 16, which the CCPA covers, from being collected and used by a third party without notice, without consent from the user. The settlement in this case was $500,000. There was injunctive relief imposed, including implementing and maintaining an SDK governance framework to review and configure SDKs within its apps. And this, to me, is the key takeaway. As part of your data governance program, mapping and governing SDKs and mobile apps should be part of a data governance program. And so this is an example of where injunctive relief around data governance is forcing a data governance program around SDKs. Another example of an SDK issue is I was representing a company who had a mobile application, and we received a letter from the California Attorney General's office saying, we used your app, we went in, and we opted out of the sale of data in your settings page, yet we could still see our data going to a third party. That's not in compliance with the CCPA. You need to explain yourself. And we were scratching our heads because the client was saying, well, that's not true. We are blocking. Here are the 8 third parties that we have tied to the app. We're blocking data going to these 8 third parties. And what happened was they had a few SDKs that were lingering that weren't properly mapped that involves third-party analytics companies. So we blocked it. We resolved it with the AG's office. But the AG's office they have a proprietary tool that they can use to scan mobile apps to see what SDKs are operating. And I asked them if they would share the result of that scan, and they said no. And I asked them what was the name of the tool they're using, and they said, we do not disclose that information. So I can't give you many more insights other than regulators are hip to this issue, and it's an important issue to flag from a data governance standpoint. Another area of legal risk that I think is driving business need to have robust data governance is the rise of privacy-related litigation, especially here in California. We have many of you on this webinar probably have received a demand letter or a lawsuit or an arbitration demand around the use of cookies, claims made under the California Invasion of Privacy Act. It is a cottage industry for plaintiffs' firms right now to bring these claims. And we're starting to see them expand out beyond just cookies and pixels. So I would say several years ago, we really saw a rise in these claims being brought by companies who are using what are known as session replay cookies. This is a third-party cookie that collects data about how users interact with your website, and then can play back a video, a recreation of that experience back to the marketing team. And the plaintiffs were arguing that the use of that third-party cookie, a third party coming in, intercepting a communication, me clicking a link with the company, is the equivalent of a third party wiretapping a telephone or a third party putting a cup against the door and eavesdropping on a conversation. And those cases have worked themselves through the courts, and the session replay cookie cases have sort of lightened up. Next, they moved to chatbots, arguing the use of a chatbot was eavesdropping and wiretapping, and those have started to become mitigated. We now have a whole wave of lawsuits brought by a particular firm alleging that the TikTok pixel is a violation of law because of TikTok's ties to China and the national security risks tied with TikTok. There's also a wave of cases around cookie functionality. There's one particular firm that is alleging that they go onto your website, they use your cookie banner, they exercise their right, decline all non-necessary cookies, and it doesn't work as advertised. They go on to other pages and they show you snapshots of the cookies are still firing. So there's this false advertising claim out there, unfair business practice claim. Again, getting to that data governance question. What's being deployed on our sites? How is it being deployed? What happens when somebody says no? Two other interesting areas of litigation that are cropping up are there are now some lawsuits, at least one, around using third-party payment processors on the credit card page of an e-commerce page where, for example, Stripe, but Stripe is not being disclosed to the user. And the allegation is that Stripe is collecting credit card information to then build risk profiles to sell to other merchants. And then there's also a new wave of claims coming up in California under the Song-Beverly Credit Card Act, which is a law from the 1970s that says when you're collecting someone's credit card to process a payment, you're not allowed to ask for extra personal information about the individual, like their address or a phone number. You can't collect anything that's not on the credit card as a condition to processing the credit card. That's essentially what the law says. And this new wave of lawsuits is alleging where you're on an e-commerce site and you get to a particular page and it says, enter your information for shipping. They're saying, well, if you're collecting phone number or email address or anything that's not strictly required for shipping and it's tied to a credit card purchase, you're in violation of the Song-Beverly Credit Card Act. Again, this gets back to mapping the data you're collecting, what's the underlying purpose, and where the risk is around that data. At Dentons, including myself, we're handling all of these different types of claims. But the key takeaway here is that there's immediate risk on not having a handle over your digital ecosystem from a data governance perspective. And that risk is paying money out of pocket to these plaintiffs' firms that are continuing to mine decades-old laws and apply them to newer technologies. And then finally, from a legal standpoint, we have our privacy risk, we have our security risk, we have our litigation risk. There are additional legal risks that you've got to consider that put an impetus on the need for good data governance. Cybersecurity being one of them. Mapping your assets, your devices, structuring appropriate controls, having visibility into your threat landscape, all critical. No matter what cybersecurity framework your business maps itself to, whether it is the NIST cybersecurity framework or the CIS controls or the HIPAA security rule or the GLBA safeguards rule, all of these frameworks require mapping and managing data risk. So data governance is a cybersecurity component. Another important legal area is IP protection, from copyright protection and understanding where your copyrights sit and how you might need to execute against them. Patent protection, IP confidentiality protections are all important as it relates to data governance. Same with trade secrets. Fidelity to the data and how the controls are set up are critical to protect trade secrets and maintain the economic value as a matter of law. And then finally, claims and liability. Having good data governance positions the company ultimately to defend against claims. Going back to these lawsuits, when the demand letter comes in and says your website is not operating as advertised, it can oftentimes be a painful process to go back and try to recreate the experience, understand what cookies and pixels are being blocked if you don't have good data governance in place. And that is a particular defense that can come into play, especially around notice and consent, if you've tracked that from the beginning. So these are just some additional legal issues that I think are important to keep on the radar. Now, before I go to sort of actionable insights, I do want to pause there and actually feel free to come off your microphone if you're able to, or populate in chat to see if there are any questions about the what and the why around data governance and the legal landscape around data governance. All right, well, hearing no questions, and again, feel free to pop them into the chat if they come up. I do want to shift gears and give you some actionable insights. It's very easy to identify it as a problem or a challenge, but the hardest part is putting it into place. And that's where a lot of organizations face challenges and issues. I think in terms of actionable data governance, the first exercise is a mapping exercise. You got to walk before you run. You have to know what data you have, who holds it, and what are they doing with it. And to me, questionnaires are effective, but meetings and one-on-one discussions are even more effective. It's with those meetings that you can identify who is going to be your data liaison, your data guardian for that particular business unit. Who knows where all the data is sitting and around the applications? And I think also these interviews are an excellent opportunity to further drive trust between whatever organization is running the data governance exercise, whether it be legal, privacy, security, and use those interviews to drive trust and get further engagement. And an example of this is I was helping out a client with this data mapping exercise, and we were meeting with HR and marketing and security and DevOps and asking them, what kind of data are you working with? How are you using it? But during each interview, we also asked them, what would make your job easier? What kind of technology? Where do you see struggles in how you're managing data and the applications? And what keeps you up at night in terms of managing data? That question generates people thinking like, oh, well, I have this great idea about this new technology that I think would work, or I think we really need to streamline this process. We then came back to them after that interview with a summary of the interview and recommendations. And we got their buy-in to say, yeah, that's what I think the recommendation should be. That makes sense for our business unit. And over time, what we found was that engaged those sort of business liaisons to further participate as you continue to identify your mapping from a quarterly, annual, or biannual basis. So I think those interviews are critical. It's a human issue, and you really need to get to know the people at each business unit level in order to really capitalize on the opportunity. So that's data mapping. Now, Data mapping can be highly manual. You can leverage vendors. I would say one consideration, and I'm biased as a lawyer, but I think when you're engaging in a data mapping exercise, you also want to think about potentially putting it under attorney-client privilege if you don't know what you're going to find, and if there are issues coming up with how data is being used, because any of those interviews, any of those notes are all discoverable in the event of an incident or regulatory investigation. So attorney-client privilege is a patina over this entire exercise that I think should be considered. The next step from mapping, the mapping exercise, is a policy exercise. What policies, what principles, what documentation do you have as an organization around data classification, around retention, around data minimization? Have you articulated what data classification looks like, what laws you're subject to, why you're classifying data in a particular way? An example of this is I was working with a client on developing their data classification policy, and they were over classifying things as personal information. And what resulted was that virtually all of the databases, all of the systems were being flagged as personal information, and therefore the controls around those systems were highly restrictive, and they were getting a ton of pushback from business. So what we did was we critically looked at whether identifiers could be removed from certain data sets in order to get more flexibility and classify it more as business confidential than personal sensitive. But the classification exercise in that policy is very important, because not only does it drive execution of your data governance policy internally, but it also allows you to show compliance if you ever get into a regulatory investigation. My experience with regulators is they're not masters of nuance necessarily when they're in an investigation. And if it's not written down, there's a prima facie evidentiary burden that you don't do it. So you could say, oh yes, we classify our data, we have data retention policies, we follow them. If it's not written down, they're going to challenge you on that. So that's why this policy exercise, I think, becomes pretty important. Classification, we talked about, it's not an easy lift, but I think it's an exercise worth having. Training and executing. This is an important component, a difficult component. Good data governance is only as good as you are training people about data governance, the importance of it from a principles-based approach. You need their buy-in. You need employees to understand why data minimization is important, why transparency is important. And shifting culture is very difficult. Sometimes I think gamifying the situation or just getting down to that human level is the most effective way. I'll give you an example of what I mean by gamifying. We was working with one client, and their biggest challenge was folks just had tons of legacy data going back over 10 years, sitting in file cabinets, sitting in email inboxes, sitting in shared drives. And we came up with a game that we called the Great Deletion Race. And we developed the rules of the game where each department had certain rules, like any data older than this date, we had to do a lot of prep work, but any data older than 2017 can be deleted outright. We had measurements and benchmarks, but the team, the business unit that deleted the most data got a pretty hefty cash prize amongst the business units. And lo and behold, they had a ton of participation, and they got rid of a ton of data. And they really solved a big problem that was going to take months to do in a short amount of time, because they made it fun, they made it interactive. So just to give you an example that this doesn't have to be a boring legal exercise. You can think about it creatively, but executing on it and training folks and getting buy-in at the front level employees, I think, is very important. Iterating and innovating your data governance program is an important concept to walk away with. This isn't something where the legal department sets up a data governance policy and then that's it. Data governance is an iterative process. It's dynamic. It's daily. Many organizations are appointing a data governance lead, a data governance officer. They have data governance boards that address privacy, security, AI, IP. And so I think, in my opinion, in my experience, what I've seen work and what I've seen that does not work, is effective data governance really requires constant vigilance and innovation. It's a lot of trial and error, especially around classification, retention, and security. But without that sort of cultural buy-in and view of data governance as an umbrella effort, it can really get siloed. You end up just looking at privacy compliance, or you end up just saying, well, we feel pretty secure on our IP protection, but you're not looking at it as a collective. So that's why I think iteration and innovation are key action items. And then finally, a big challenge that I see internally at organizations is getting executive and board level buy-in to an approach, a robust approach to data governance. And when you approach data governance simply as a compliance or a legal or security function, I've seen firsthand that boards and management sometimes see it as a cost driver. This is just another line item cost. And in a tight economic environment, this isn't a strategic priority. But I see data governance in a different light. I actually see it from a principled approach as a business driver, not a business cost. And that is because if you do data governance right and you invest the appropriate resources and you address it as a holistic exercise within the organization, it actually positions you much better to obviously mitigate risk and drive compliance, but also take advantage of new technologies, understand your customer base better, deeper analytics, better fidelity to historic data and how you're using it, and a closer understanding of how business units are actually using and deploying data and applications. That to me is the sweet spot in sort of advocating for more resources to drive a data governance program. I had a client whose CISO was trying to put in place a more robust data governance approach, not just have it all be a security functioning following under the CISO's role. And we worked together to talk about presenting to the board of directors the need for more resources to have a more holistic data governance approach and all of the different opportunities in the business to where data governance would actually drive revenue. We didn't even talk about compliance. We did a little bit about risk, but it was more about driving revenue. And that helped him get the resources he needs. So I think this is an important takeaway in thinking about data governance as a whole. So if I were to wrap this all up in a bow and say, what do you want to walk away with? One is data governance is a cultural approach. It's a principled approach to managing data. It's not just a compliance function. It's not an easy process, and it shouldn't be a static process. And ultimately, I think if done right, using the right technology, engaging the right outside partners, and engaging with the right internal partners, it can be used as a business driver, a revenue driver, and not just a cost center for your organization. So with that, I know we have about a minute left, a little under a minute. Happy to take any questions if there are any on the chat. Of course, if you want to populate any questions, feel free to do so in the chat function. And of course, as always, if you have any questions about data governance, the approach to data governance, feel free to reach out online, and I'd be happy to chat with you by phone or grab a cup of coffee. All right. Well, I think everyone is fully immersed in data governance talk. So that's a good sign.
No, it was very helpful. Thank you.
Terrific. Well,
Good
thank you,
refresher.
everyone. Appreciate your time.